Good morning. Welcome to the Maryland Public Service Commission. This is a hearing in docket numbers 9618 and 9645 with respect to alternative rate plans or methodologies to establish new base rates for an electric company or a gas company. This is also cross-docketed with respect to the Baltimore Gas and Electric Company's application for an electric and gas multi-year rate plan by order issued on October 28, 2022. This has been noticed as the time and place for this hearing today to address the Lessons Learned report that was filed by Commission staff on June 30th, 2022, which outlined a number of areas that the Commission should revisit, as well as some requests for updated filing requirements that were contained as a redlined appendice to the staff's June 30th filing. At this point, I will turn it over to Commission staff to begin. Ms. Garofalo, any opening statement?
Yes, Your Honor. Good morning, Mr. Chairman, members of the Commission. Annette Garofalo on behalf of Commission staff. With me this morning to address the issues in the Commission's Lessons Learned report order are Jamie Smith, Director of the Accounting Investigations Division, Drew McCullough, Director of the Electricity Division, David Hoppick with the Energy Analysis and Planning Division, and John Borkowski, Head Engineer of the Engineering Division. I would like first to address staff's understanding of BGE's pre-filing activities in the next MRP. The Lessons Learned report does propose that cost of capital and class cost of service testimony be provided early, and that basic forecasting testimony describing methodologies used to forecast revenue requirements for each year of the MRP, as well as billing determinants, should also be provided early. I think the issue of the forecasted billing determinants has been somewhat resolved, and we are not asking for rate design items on a pre-filing basis. Rather, we are asking for, and I think BGE has and remains willing to provide detailed billing determinant testimony through a single witness with discovery conferences on this topic as necessary, including discovery during the usual period. Mr. Hoppick will address billing determinants related issues in a more detailed fashion next. Also, as the Commission notes in its order addressing the Lessons Learned report, recent legislation extends the suspension period by 90 days. This additional time period, in combination with the fact that BGE's next MRP will not be the first such case considered by the Commission, makes the necessity of early cost of capital and class cost of service testimony less necessary, and this was actually not the case when we wrote that portion of the report. Thus, staff is not seeking pre-filed direct testimony in BGE's coming MRP. Mr. Hoppick is available to answer questions regarding billing determinants and other related issues that you might have. Mr. Smith is available to answer any additional filing requirement questions the Commission may have. Mr. McCullough and Mr. Borkowski are available for questions as well.
Thank you, Ms. Garofalo. Did Mr. Hoppick, did you say, have any presentation to provide?
I believe he does.
Okay.
Have it very short.
Well, we'll turn to Mr. Hoppick. Good morning.
Good morning, Chairman and Commissioners. David Hoppick on behalf of Commission staff. I will address the 8 informational categories related to billing determinant forecasts that were included in the Lessons Learned report, and whether they will be provided to parties in BGE's initial filing in its next rate case. 6 of 8 of the informational categories are directly addressed in the revised filing requirements. I will specifically address the 2 that are not directly addressed. That is number 4, concerning external data used in the model, and for electric vehicles, energy efficiency, distributed solar, out-of-model adjustments, and information about external data sources. And number 6, understanding model coefficients. Regarding number 4, the filing requirements do not include specific requirements for data used for energy efficiency, electric vehicles, distributed solar, out-of-model adjustments, or specific information about external data and sources. However, it is staff's understanding that the requirement in the filing requirements to provide all data inputs means that parties will receive all input data used for energy efficiency, electric vehicles, distributed solar, and out-of-model adjustments, along with documentation, so parties understand these input variables and data. Similarly, filing requirements do not require information about external data sources, such as explaining when data comes from an outside consultant or another modeling source, as is often the case with things such as forecasts of electric vehicles in a service territory. BGE has told staff that it is agreeable to providing this information in its initial filing in its forthcoming MYP. Regarding topic 6, the understanding model coefficients, this primarily entails whether the model variable coefficients make theoretical sense and how this relates to whether certain variables are included in the final models used. For example, theory says sales should decrease with higher prices, but if the coefficient for price in a model is negative, which could occur due to weather and other factors, staff would want to see an explanation of why the model may give a result that does not align with theory, and an explanation of why or why not this explanatory variable is included in the final model. This was provided in the most recent MYP filing by Delmarva, and BGE has similarly agreed to provide this in its forthcoming MYP filing. Thank you. I am available for questions.
Thank you, Mr. Hoppick. Ms. Groffalo, any additional staff wish to open?
We're just available for questions.
Thank you. We'll go down the line. Office of People's Counsel. Good morning.
Good morning, Chairman and Commissioners. I'm Nikki Wiggins here on behalf of Office of People's Counsel. We don't have any opening comments. I'm just here to address any matters that might come up at the hearing.
Thank you, Ms. Wiggins. We'll turn to the utility. Good morning.
Good morning, Commissioners. Beverly Sikora on behalf of BG. I also have John Crane with me here today. We agree, or BGE notes that staff now agrees that pre-filing testimony is not necessary given the extension of the 90 days. We also had indicated that given the extension of the 90-day timeline, that would be very infeasible for us to be able to provide that information in order to meet the deadline for getting new rates into effect. We are agreeable to the additional information that Mr. Hoppick has asked for. We realize that some things came up during the Delmarva case that we hadn't discussed during the lessons learned, so we're definitely willing to provide that information in our filing. And lastly, concerning I know the Commission had some questions about the draft or the minimum filing requirements that were filed with the lessons learned report. BGE is agreeable to all of the changes that are reflected, except on page 16. There are a series of 5 comments that were left in, and those were actually comments that I had drafted that we needed to undo some changes just because we were using a wrong version of kind of a starting point. And so
So, Ms. Sikora, those 5 comments, A3 through A7, are yours?
Yep, those
Okay.
are mine.
And I'm sorry, what are we to do with those comments?
The comments were that the changes that are reflected in those 2 sections really should be rejected because we were staff had used the wrong version of the filing requirements that we'd agreed to in phase 2 of PC 51 or 9618. And so it was just an error in terms of a starting point.
So everything in purple should be deleted. Is that correct?
I don't know if deleted, but it needs to be reversed, because in some cases, things were being deleted, they need to be left in.
Restored.
Yes,
Okay.
Yeah.
So everything in
Undone.
purple is the opposite of what it appears to be.
Right.
Okay, all right, restored is the right word.
yes.
Thank you, Ms. Sikora. You're making this very, very easy. I was looking through our October 28th order. I believe that we've addressed the timeline question. BG does not object to any of the requests made by staff that I have flagged in the order. Is that right?
Nope, we're good. And we'd also be willing to file a clean copy of these, so that we get rid of all the editing, and so you have a nice, clean.
That would be helpful. I was under the misimpression, I thought this was staff's working document, but this was BGE's.
Well, it was a working group document that, was going back and forth between parties. I remember making those comments on a draft at some point, but it looks like that the draft that staff then used didn't actually carry through with the comments and didn't delete them, so.
Your Honor, related to that, can we just go back and verify? I know there was a lot of back and forth, so I just want to make sure that, in fact, I see what Bev's saying. I believe that's probably true, but we'd like to go back and verify we're in agreement with that.
Why don't you take 7 days, and then you can make a filing to give yourself the time to ensure that everything here is correct, particularly with that section. Let me ask Ms. Wiggins, any concerns with the updated filing requirements?
No, nothing here specifically related to BGE's next case, Your Honor.
Thank you. Well, I commend the parties. The multi-year rate plans have been challenging for all parties involved, including, I would suspect, those of us up here on the panel. This is a voluminous list of pre-filing requirements, hopefully the additional 90 days by statute. It'll make some adjustments both for the utilities and for staff. But now that we've reduced many of these to writing, and the utilities could plan out into the future if they know they will be filing an MRP, it should become, I wouldn't say cookie cutter, but more predictable in future rate cases. I don't have any questions based on what I heard from Ms. Garofalo or Mr. Hoppick. Do my colleagues have questions of staff? Commissioner O'Donnell.
Actually, my question's for the company.
Or the questions for, we'll open it up to questions for anybody.
Okay. Ms. Sikora, could you repeat what you said towards the beginning with regard to you're happy that staff has now agreed that with the extended time frame that was passed? Could you repeat that to make sure I heard it right?
In the report, it kind of suggested that we still needed pre-filing testimony. The Lessons Learned work group kind of went over an extended period of time when I'm already drawing a blank on the number of the bill that extended the time frame by 90 days. So I think when we were originally talking about it, it wasn't official yet, and so, it wasn't quite certain that was going to be passed and put into effect. So I think there was a little bit of confusion maybe about whether or not that 90 days would really actually happen. And so, if that didn't happen, pre-filing testimony still might be appropriate, but now that it has, passed, it's in law, it really isn't necessary.
So I just wanted to verify, we're only talking about testimony. We're not talking about pre-filing of all the other information.
No, there will be no pre-filing of
Anything?
Anything.
Okay, no pre-filing of anything.
Yes, I'm sorry. I should
So
have
that's what gives me some concern, some pause, even with the extended timeline, and I agree with that, but what does that do potentially to the transparency issues that we're dealing with in regard to distribution system planning? Because there's a whole bunch of people who'd like to start looking at some of this stuff and evaluating it in terms of a rate case. And yeah, they're going to have a little more time, but it's going to be filed.
Unfortunately, I don't believe that anything we had included in the pre-filing testimony and information in our last case really even got to kind of the DSP type issues.
I understand that, and that's part of the issue that we ran into was the lack of transparency and
Correct.
getting the utilities to change their paradigm with regard to transparency.
We're willing to, we're going to provide as much information as we can in our initial filing. Unfortunately, the DSP proceeding has not maybe gotten as far as we had hoped, and so that we would have had a little more clarity or would have been little bit further along in that proceeding, so that information that could be helpful in our case would have been already available. But again, we will do what we can to make sure that people know what we're proposing and understand it. We definitely during our preparations are looking back at comments that were made by the parties in the commission about the information that we provided, and we are updating various things to make sure that we're providing additional information about the projects. We provided, or we had sessions with staff and other parties in the case during the course of the proceeding to walk them through various processes and documents, and we certainly are willing to do that again. We just, at this point, we definitely are making modifications based on what we learned from the last case. But unfortunately, there's not a lot that we can change based on the DSP proceeding just because that hasn't gotten to the point of giving us any guidance.
Yeah, so, there was definitely benefit to pre-filing information. I get it. There's benefit to extending the timeline. I get it. I agree with all of that. But I'm not sure we're taking full advantage of the lessons learned, because one of the things we learned was there was a lack of transparency. And I'm not sure that doing away with the pre-filing requirements helps change that to the positive. In fact, it may make it more difficult, is my thinking. So what's staff have to say about that?
Okay.
I know they're fine. I wanna
Good morning, John
justify.
Borkowski for staff. I do note that there were several additions to the filing requirements which will help with transparency. Now, we recognize that, we don't have a DSP process as far enough along, but I hope with those enhancements in the filing requirements, we will have more transparency, especially when it gets to the benefits and things of that nature of the projects. And, as the commission indicated in its order related to this proceeding here, basically, the commission reserves the right, and I'm looking for the appropriate reference, but the commission retains a discretion and authority to reject or modify a proposed MRP that is not providing sufficient transparency or justification of the utility proposal. So we'll have to do our best, given the filing requirements, given our discovery, and if we don't feel the company is being transparent, we'll have to highlight that with the commission.
What does Office of People's Counsel have to say about this?
Similar to what Mr. Borkowski just said, we're hoping that the updates to these filing requirements will provide an additional level of transparency that we didn't see in the first case. We don't know what we're going to get specifically from BGE, so can't comment on what we see, but we'll continue to flag issues as they arise, and what's making it more difficult for us to see and comment on their spending and their projections. I think the report notes that this lessons learned report isn't going to take the place of a full lessons learned report coming after the termination of the MRP or regulations that the commission sets. So I think these questions are going to continue to be evaluated, and we're going to continue to apply best practices, especially after the DSP process concludes. We can kind of build in learnings from that into these MRP proceedings to make the process more transparent and better for BGE's ratepayers as well, so they can see, have a little bit more insight into the spending. So that's where we are. We're hoping that the requirements that we've put in based on this lessons learned report help to resolve some of those issues.
All right, fair enough. I wanted to have a discussion of that because I don't think this issue is going to go away with regard to transparency and how multi-year rate cases and distribution system planning kind of intertwine. And I know one of the lessons we learned from the first rate case, from the pilot rate case at BG&E, was the lack of transparency, undoubtedly. And what we also learned in the second rate case from Pepco was they didn't learn the lessons learned from the first rate case. So they repeated all those. And I'm concerned in this, and that, and we've had a third multi-year rate case now, which had a substantive settlement agreement, so I can't even evaluate that for what was there and what the parties thought of all of that. But at least wasn't able to cross-examine anybody. But I don't know. I don't know what the answer is. I'm certainly gonna take the recommendations of the parties represented here, but I think going forward, we may come to the point where we say we need some pre-filing of information again. So let's chalk this discussion up under the "I told you so" maybe heading if that occurs. Okay, thank you, Mr. Chairman.
Thank you. Thank you to Joe Cleaver. The memo is in the record. Hope he's doing well at FERC. All right, procedurally, we'll need to get out an order. I suspect it'll be brief. I suspect we could quickly issue an order, but we'll give a grant to Mr. Smith's request, 7 days till November 29th, to take one additional peek. Any party, including OPC, if you have any issues, bring them to our attention by then. Of course, please be in touch with the utility before you file, and then the commission will issue a determination in response to these red line filing requirements. Before we conclude today, anything from the bench, anything from the table? Thank you. This hearing is adjourned.
Thank you.